Bismillahirrahmanirrahim. Learned viewers, this is me, Majid Alibat, advocate from my YouTube channel. And today I am going to discuss with you about the interview process and questions asked in the interview by the NAB for the post of Special Prosecutor for High Court. May I tell you that when I was called upon for the interview, I tried my level best to get some material, relevant material from the YouTube and other relevant concern, but unfortunately, I could not get some relevant material which could help me or give me some confidence that that what are the questions are being asked by the interview panels. But when my interview was being conducted by the NAB authorities, so I just made my mind that I will upload a very informative video regarding the process of and the questions of NAB interview for the post of Special Prosecutor for High Court. First of all, I believe that the candidate should know about the hierarchy of the NAB, that who is the chairman of the NAB, what are the authorities and functions of the chairman NAB, and who is the prosecutor general of the NAB, and what are the functions of the prosecutor general of NAB, and how many regional offices are there in whole Pakistan of the NAB. All these things are enumerated in different sections of the NAB ordinance. Therefore, the candidate should gone through this NAB ordinance. This NAB ordinance is a very short booklet. It only contains 37 sections. Although all the sections of NAB ordinance are not as important as some selective ones are. Therefore, keeping in view the importance of some selective sections, I gathered some sections which are being frequently asked by the interview panels, and these are section 5, 6, 8, 9, 10, 11, 16, 18, 22, 24, 25, 32. These 12 sections are most important sections. So the candidate who is intended to appear before the NAB prosecutor interview, he should have all these sections on his fingertips. And most frequent question being asked by the panel, that when the candidate appeared before them, they ask, have you gone through the NAB ordinance? Obviously, candidates say yes. Then they ask that how NAB take cognizance of the offence. There are three modes in which the NAB take the cognizance of an offence, that is enumerated in section 18. The NAB reference, number 2, by complaint of any person or by NAB. Then the second most question is, what are the grounds of arrest under NAB law? Section 24 deals with the grounds of the arrest by the NAB. There are 4 grounds of arrest. Number 1, accused intentionally not joining in investigation, accused attempt to abscond, accused there is apprehension of tampering of evidence by the accused, apprehension of repetition of the offence. These are the 4 grounds of arrest that is enumerated in section 24 of the National Accountability Ordinance. Then the question which is mostly asked, that what is the provisions which deals with the remand and what is the period of remand. Earlier it was 90 days remand period, but now when the NAB law is being amended by this government, now 90 days remand is reduced to 14 days remand. And again, section 24D deals with the remand of the accused. Then there are some differences between different terms being used in our different laws. For example, the NAB interview panel can ask you that what is the difference between voluntary return and plea bargaining. this section, the section 25 of the NAB ordinance deals with this voluntary return and plea bargaining. Voluntary return means that before the authorization of the inquiry by the chairman NAB, if the accused person shows his willingness that he is ready to return the alleged amount that is supposed to be gained by him through corrupt practice and corrupt means. Plea bargaining means that after the authorization of the inquiry or during the trial or even after the trial at the appeal stage, the accused person get ready to submit all the amount that is being alleged upon him that he has gained through illegal means is ready to submit in the government treasury. That is called plea bargaining. One more question which is being frequently asked, that what is the difference between challan under section 173 CRPC and a NAB reference. So the candidate should know that when an ordinary case is being probed by the investigating officer, like in Punjab, like by the Punjab police or any other FIA authorities, and after conclusion the whole investigation, when they submit the whole incriminating material before the court for the trial of the accused, that is called challan under section 173. But when the investigation is being conducted by the NAB authorities, NAB investigating officer, and after conclusion of the inquiry or investigations, the whole incriminating material is being submitted before the accountability court, that is called NAB reference. That one more question, that what is the difference between admission and confession? Candidate should know about this admission and conviction. Then what is the difference between discharge and acquittal? Difference between session trial and magisterial trial, and what are the different types of the trial? What are the difference between mode of acquittals? How many modes of acquittal are there? Candidate should know that 265N and after trial 265K CRPC at any stage of the trial. Then stages of the session trial, section 265A to 265K, stages of the trial. And then what is the purpose of the NAB? Purpose of the NAB is to eradicate corruption and recover looted amount from the culprits. Then what is the difference between primary and secondary evidence? As the NAB cases are mostly based on documents, therefore the candidate should have a strong grip on the documentary evidence. And the relevant section of the Queations ordinance, that is Article 73 and 74, that deals with the documentary evidence, he should fully equipped with these sections. NAB documents mostly based on electronically generated modes. Therefore, Queations ordinance section 164 is most relevant, and the candidate should have fully knowledge about the Article 164 of the Queations ordinance. As the accountability courts are equivalent to the district and session courts, therefore the modes of the trials are the same as are being conducted in session trial. Therefore, the candidate should be well aware about the different stages of the session trial. Section 26 of the National Accountability Bureau deals with the tender of pardon. What is pardon means, and who is eligible for this pardon, and what are the ways for the for grant of the pardon, and who is authorized to grant this pardon. These are the very relevant questions which are being enumerated in section 26 of the NAB. So the candidate should thoroughly go through the section 26 of the NAB. Also, the concept of compliance is very important, and it is frequently asked that what do you understand by the compliance? CRPC sections 337, 338, and 339 deal with the concept of compliance. Therefore, the candidate should read all these sections of CRPC in order to know about the concept of compliance. Section 32 of the NAB deals with the appeal. It is very important to mention here that this section 32, which deals with the appeal, has two categories. When the appeal is to be filed by the private person, the time limit of that filing of appeal is 30 days, and when it is to be filed by the government, then there is 6 months period for filing of appeal. So candidate should know this difference that is enumerated in section 32 of the NAB. The concept of proclaimed offender is very important and frequently being asked by the interview panel of the NAB. Concept of proclaimed offender is very important one. And what are the sections that enable the authorities to proceed against the proclaimed offenders? Candidates should know about these sections, and these are section 87 and 88 of the Criminal Procedure Code. Appeal against acquittal. This is very important question. Again and again, that is being asked by the interview panel. That what are the sections that deals with the appeal against acquittal? That is section 417 CRPC. Criminal revision under section 439 before session and under section 439A before High Court. Criminal revisions concept must be in the mind of the candidate. What would be the forum of appeal against the accountability court's order or judgment? DB will hear the appeal against the acquittal or appeal against the conviction, which is a section that deals with the appeal against the conviction, that is section 410 CRPC, suspension of sentence under section 426 CRPC. One most important question that is almost being asked to each and every candidate by the interview panel, that have you ever conducted any NAB case? So if you have already experience of conduction of NAB cases, then it would be very favorable for you. As you all knows that NAB was supposed to be called a draconian law. That's why in 2023 government made some amendments in that NAB law. Actually, that NAB law was originally formulated by the dictator General Musharraf. There were some provisions that were supposed to be against the fundamental rights of the accused. Therefore, most of the time, the interview panel asks you the question about the amendments made in 2000, that whether these amendments are good in your opinion or bad one. So most of the amendments made are good. For example, remand of 90 days, that is supposed to be very inhuman, that for 90 days a man is being kept for nothing. Otherwise 14 days are enough to investigate, because NAB prosecutions mostly based on documentary evidences, and at the inquiry stage and investigation stage, the NAB investigators have already collected all these things. So 90 days remand was inhuman, and in that amendment that was made in 2023, that 90 days remand was reduced to 14 days. That is a good amendment. And second amendment, that the burden of proof shifted on the NAB to prove the prosecution case. Look, this is inhuman because in earlier NAB law, it was the person against whom the whole state stands and says that you are guilty. No, it is the responsibility of the that person to show that I am innocent. This is against the universal principle of the prosecutions. This amendment is supposed to be the good amendment. No extension in chairman NAB employment. Sometimes NAB chairmen bargain for the second term, but in this amendment, it is this chapter is being closed that once a person appointed for 3 years, he will not be able to get the extension. Rules of NAB shall be subject of the National Assembly. All the rules shall be made by the approval of the National Assembly. No public servant shall be held responsible for irregularity of procedures. First, in previous NAB law, when a person who have to, especially the bureaucrat who have to take the decisions, and they were subject to the NAB prosecution at any time, they being dragged in the NAB prosecutions. That why you did, why you ordered that, why you sanctioned that grant. No amendment is brought in the NAB laws that on the basis of irregularity of the procedures, the bureaucrats or the authorities will not be prosecuted by the NAB. Inquiry against any financial institute shall be subject to the prior approval of the State Bank. Any financial institutes who have to take the decision on some point of time, but they always remain under the fear of the NAB prosecutions. But this amendment is being made that before to take any prosecution against the financial institutions, State Bank prior approval is necessary. That actually enhance the monetary role of the State Bank. Disposal of the case shall be in 1 year instead of 1 month. How is it possible that within a 1 month you conclude the whole trial? So amendment was brought that it will be not 1 month, rather it will be 1 year. No rules are to be made by the federal government. In previous NAB law, it was the chairman who, with the consultation with the president, but now this authority of the NAB chairman is being taken back, and it is the federal government that will make the rules. NAB is bound to submit annual report before National Assembly and Senate. Right of bail was granted. Earlier, there was no right of bail granted in the previous NAB law, and all the bail petitions were being filed in High Court under Article 199. But but in this amendment, right of bail was granted. So all these above mentioned amendments are quite good amendments, and these attract the prudence of a general man. About the general knowledge questions, name of the Chief Justice of all five High Courts and Supreme Courts. Which law was repealed by National Accountability Ordinance? Actually, it was Ihtisab law that was repealed by the NAO, while NAB law is called ordinance. Why NAB law is called? Because it was initially promulgated by the president, therefore it is still called National Accountability Ordinance. Otherwise, now it has become a act of parliament. Now it has become act of parliament, but even then it is called National Accountability Ordinance. The parliament, while making it act of parliament, did not consider that we should not change the name of that ordinance. Under what article President promulgated ordinance, and for how long an ordinance is valid? Article 89 of the Constitution of Pakistan empower the President to promulgate the ordinance, and ordinance remain in force for 120 days. So viewers, I think the most important and most relevant and most frequently asked questions I discuss with you in this video that are being asked by the interview panel of the NAB, and I'm sure that will be helpful for all those aspirants who are intended to be NAB Special Prosecutor for High Courts. If you like this video, kindly subscribe my channel and I wish you best of luck. Thank you very much for watching this video.